Does anyone believe if President Trump wasn't running for president that he would be facing 4 criminal trials? Fani Willis announced her investigation in February of 2021, but didn't bring charges until 2.5 years later after President Trump announced he was running for president. Attorney General Garland named Jack Smith special counsel 3 days after President Trump announces that he's running for president. And Alvin Bragg said he could not see a world, quote, he could not see a world in which he would indict President Trump and call Michael Cohen as a prosecution witness. But that's exactly what he did after President Trump announces he's running for president. Alvin Bragg brings a case that the Department of Justice wouldn't, that the Federal Elections Commission wouldn't bring, that his predecessor, Cy Vance, wouldn't bring, and as Alvin Bragg himself said, he wouldn't bring, but then he did after President Trump announced he was running for president. Some might call this all election interference. Think about it. Mr. Bragg is charging President Trump with conspiracy to impact the 2016 election. Ms. Willis and Mr. Smith are charging President Trump with a conspiracy to interfere with the 2020 election. Seems to me the conspiracy is between Bragg, Smith, and Willis working to interfere with the 2024 race. Of course, none of this is new. 2016, government spied on President Trump's campaign. You don't have to take my word for it. You don't have to take this committee's word for it. John Durham said it. Clinton campaign paid the law firm Perkins Coie, who hired Fusion GPS, who hired Christopher Steele, a foreigner, who talked to other foreigners, who put together the fake dossier, which became the basis for the FBI to spy on President Trump's campaign. The basis for a whole investigation where we saw text messages back and forth from folks on the investigation saying, "We'll stop Trump." Then, of course, it was the Mueller investigation. 19 lawyers, 41 FBI agents, $30 million to find nothing. No conspiracy, no coordination, none whatsoever. Then it was impeachment. Anonymous whistleblower with no firsthand knowledge, who was biased against President Trump, who worked for Joe Biden, talks about a phone call and they impeached the President of the United States. Then they raided his home. Broke every protocol, every normal procedure. Again, don't take our word for it. Stephen D'Antuono, FBI Assistant Director of the Washington Field Office, told us this in his deposition. Then, of course, they tried the 14th Amendment. We'll just keep him off the ballot. The easiest way to win is not to let your opponent play. That's what they tried to do. Thank goodness the Supreme Court said no to that. 9-0, they said no to that. And then, of course, after all that, after he's a candidate, as I said, we get all these cases. In Georgia, Fani Willis hires her boyfriend, who travels to D.C. on the taxpayer dime, meets with White House officials, January 6th committee, all in an effort to target President Trump. In New York, gag orders placed on President Trump by a partisan judge whose daughter is a Democrat fundraiser, while Michael Cohen, convicted perjurer, is allowed to post anything he wants on social media, say whatever he wants. Not to mention the guy who's the lead prosecutor for Alvin Bragg, Mr. Colangelo, who worked for Letitia James, then worked for the Justice Department, then went back to New York to work for Alvin Bragg. And in Florida, we learned that Jack Smith altered the order of the classified documents he seized. The physical documents don't match up with the scanned documents. Jack Smith didn't properly handle the documents he said President Trump didn't properly handle. Jack Smith mishandled classified information, all while charging President Trump with, quote, mishandling classified information. You can't make this up. Some would call that tampering with evidence. Today's hearing is about how the law is being used to target political opponents. It's truly about the weaponization of government, truly about what this committee has been focused on for this Congress. And obviously, President Trump is example number one. It's about the double standard, one set of rules for the politically connected, the other set for the people they want to target. But maybe most important, it's about where does all this go? Where does it all go? Because if they can do it to a president, they can do it to anybody. Any one of us, any of our constituents, any American they want to. And that's what's frightening. That's what's truly frightening. So I want to thank our witnesses for being here and talking about this most critical issue, how the government, how the agencies, how the law is being turned on people that they politically disagree with.
The gentleman yields back. I now recognize Ms. Stefanik for 5 minutes.
Oh, I love being able to respond to the novice from New York. First of all, thank you so much for stating the obvious that political lawfare is in fact election interference. That's what we're seeing with the sham Alvin Bragg trial. Thank you also to the novice freshman member for New York, highlighting that withholding military aid to an ally for a political purpose, just like Joe Biden is doing to Israel. Always grateful for you stepping in it. Mr. Costello, in your opening statement, you said that in the over 50 years serving as a lawyer, you, quote, have never seen the types of politically motivated cases that have been brought in this presidential election season. These political cases are being used as a weapon of war to damage, defeat, or impede political adversaries and their allies. Instead of political warfare, it is lawfare, a cancer upon our collective judicial system. I want to begin with Alvin Bragg's weaponized sham trial in New York. Isn't it true that in Alvin Bragg's campaign for Manhattan DA, Bragg specifically ran on going after President Donald Trump?
That is true.
Isn't it true that Bragg's predecessor, Cy Vance, declined to prosecute President Trump?
That is true.
And the FEC also did not prosecute President Trump.
That is true.
And the DOJ did not prosecute President Trump in this case.
The DOJ referring to the U.S. Attorney for the Southern District?
Correct.
Absolutely true.
And one of the reasons the Southern District of New York turned down this case was because the supposed star witness, according to Alvin Bragg, Michael Cohen, was totally, quote, unworthy of belief. Isn't that true?
Without a doubt.
This is the same Michael Cohen who pled guilty to 7 counts in an indictment that had absolutely nothing to do with President Trump and actually predated the first time he met President Trump, correct?
Absolutely true.
And in fact, this is the same Michael Cohen who perjured himself to Congress. Isn't that true?
Yes.
In fact, when called as a witness in this sham trial, Cohen was asked directly if he was honest during his testimony to Congress. He said no, admitting perjury. But it's not just Bragg's case that is a total sham and illegal political lawfare going after Joe Biden's top political opponent, Donald Trump. This rot goes deep all the way up to the top in the Oval Office. Because when Congress referred this admission of Cohen's perjury to Joe Biden's DOJ, isn't it true that the DOJ has refused to prosecute?
That is true.
Isn't it correct that Michael Colangelo, who was the 3rd highest ranking official in Biden's DOJ, was transferred to Bragg's office to run this weaponized prosecution of President Trump? Isn't that true?
Not only true, but it's unheard of.
Unheard of. It's a disgrace. Do you agree that this weaponization of lawfare goes straight to the top with the purpose of helping Joe Biden's failing presidential campaign?
The circumstantial evidence definitely supports that.
And the unconstitutional gag order on President Trump from New York Judge Merchan is unprecedented lawfare.
As far as I know, absolutely.
And let's go to the daughter of the judge. Isn't it true that she is raising millions of dollars off of this sham case?
Well, I have to say I've read that in the media. I don't know it of my own knowledge.
It is true.
Thank you.
One additional question. I want to talk about the rigged and unprecedented jury selection process. Isn't it true that Bragg's team asked the jurors if they followed Trump on social media?
Yes.
And isn't it true that they did not ask any of the potential jurors if they followed Biden on social media?
Or Michael Cohen.
Or Michael
Yes.
Cohen.
Yeah.
And isn't it true that 87% of the jurors said they voted for Joe Biden?
That's true.
Is this unprecedented and lawfare jury shopping?
Without a doubt.
Without a doubt. Political lawfare for the purpose of election interference to go after Donald Trump. Do you agree?
Totally.
This is one of the reasons that Trump's polls continue to skyrocket, and it's why President Trump will win in 2024 to end the illegal and warped weaponization of the justice system, because if they can illegally go after Trump, they can go after anyone. I yield back.
The gentleman from Florida is recognized.
From the testimony of Michael Cohen's lawyer, Mr. Costello. These days, you see individuals running for prospective office who claim, if you elect me, I will bring down this public figure or that public figure who disagrees with my political philosophy. Understand that to destroy a political rival, you need not convict that person of a crime. all you must do is leak the fact that the individual is being investigated for a particular crime, thereby destroying his or her reputation and causing that individual to incur legal fees to defend themselves. The net result is, if you can destroy their reputation and bankrupt them with legal fees, you have effectively eliminated or canceled your opposition without ever convicting them of a crime or getting a civil judgment against them. Mr. Costello, I just wanted to say I felt very seen by your testimony that was provided to the committee. But I want to get back to what Mr. Lynch said previously, that sometimes when you're accused of something, it's actually the people accusing you who are doing that thing. Now, you were accused of illegally dangling a pardon before Michael Cohen, right?
Correct.
And that was a lie.
Absolutely.
That accusation could not withstand any scrutiny or review from the Southern District of New York, where Mr. Goldman worked, where other great attorneys have worked, right?
And where I worked.
Right, but that dangling,
Correct.
that accusation of dangling something improper. Remember what Mr. Lynch said. If you're being accused of that, maybe it's the people doing the accusing. Now, Mr. Trustee, you described a searing fact pattern moments ago. You accused a Department of Justice official of an extortionist ploy to dangle a judgeship before a lawyer to get that lawyer to betray their client, Walt Nada, right?
Yes, I have no reason to disbelieve that lawyer.
And who was the Department of Justice official that engaged in that extortionist ploy?
Well, the lead person in that conversation was Jay Bratt, who's still currently assigned to the Southern District of Florida case.
What is that? I mean, for those of you who've been prosecutors, who've dedicated your lives to the rule of law, what does it tell us about the shape of the legal system that you have people with the ability to do what Mr. Costello laid out in testimony, to charge you with a crime, destroy your reputation, bankrupt you, like they're trying to do to Walt Nada, a patriot who served in our military, and then to hear this claim that they were literally trying to compromise the lawyer? How should we reflect on a legal system that permits that?
It's broken. I had a friend of mine from the Department of Justice text me not too long ago, and he said, it's going to take decades for the department to fix itself. And I love that place. I worked there. I was a prosecutor for 27 years, but I am fearful that we've crossed the Rubicon by being ends justified the means, by engaging in selective targeting and differential treatment. And I don't know how it ends or how it gets better, but I'm happy to at least bring evidence about that issue.
Well, and that's why these hearings are so necessary. I think that we would love to stay well constrained within our Article 1 lane. But when we've got this Article 2 process that is unloading on political rivals and Article 3 courts, as Mr. Costello said, the only way to have a check and a balance on that system is for the Congress to step forward and to utilize its tools, the most profound being the power of the purse, but indeed we have powers of impeachment and oversight that are important as well. Mr. Costello, is Michael Cohen a liar?
That doesn't begin to describe him. He lies at every opportunity when it's in his favor. And I mean, I could, if you had a half an hour or 45 minutes, I could start to list the many lies that he told us.
Well, let's just triage them. Is there a single branch of government that Michael Cohen hasn't lied to?
Gee, I think there isn't.
Right. I mean, you really have to work hard to hit the hat trick. I mean, it's one thing to lie to investigators. And I guess it's another thing to lie to Congress, but to lie to investigators and then Congress and then courts.
Don't forget the judges.
Yeah, the
He
judges.
lied to the judge, too, when he pled guilty.
And it's just so odd. I mean, it's not every day you see someone's former lawyer having to come forward and say, I regrettably have to inform the Congress, the court, whomever, that my own client, I am aware, is a liar.
Thank goodness he was foolish enough to execute the waiver of the attorney-client privilege because he was trying to implicate Rudy Giuliani and myself in a crime, which was absurd.
He even lied about that. He even lied about trying to turn on you, and I guess his lies are defied by his other lies and the writings and the paperwork, and this liar should not be able to hold our elections hostage, and that is why this hearing is so critical. I yield back.
Gentlelady from Florida is recognized for 5 minutes.
Thank you, Chairman Jordan. And thank you to all of our witnesses for appearing here today. I'm just going to start going right down the line with a simple question. When a candidate campaigns for office, they make promises, correct? We'll start with you, Mr. Costello.
Correct, obviously.
Want to be a dictator.
Mr. Trustee, Mr. Hamilton?
Yes.
Yes.
One makes, wonderful. So I'm going to dig into what the prosecutors and plaintiffs have said about Mr. Trump here recently. Alvin Bragg, during his campaign for New York County District Attorney, said, quote, "I am the candidate in the race who has the experience with Donald Trump. I was the chief deputy in the Attorney General's office. We sued the Trump administration over 100 times. For the Muslim travel ban, for family separation at the border, for shenanigans with the census, so I know how to litigate with him," end quote. In response to another question from a reporter, Bragg said, quote, "We've got two standards of justice. Harvey Weinstein, Jeffrey Epstein, being a rich old white man has allowed you to evade accountability in Manhattan. That includes Trump and his children," end quote. Moving on to New York Attorney General James, during the last days of her campaign, said of Trump, quote, "Oh, we're definitely going to sue him. We're going to be a real pain in the ass," end quote. She would later go on to say, quote, "I will never be afraid to challenge this illegitimate president," end quote, and said, "What is fueling," quote, "what is fueling my soul right now is Trump," end quote. Mr. Costello, is there a financial benefit to making campaign promises?
I'm sure there is, otherwise she wouldn't have made those promises.
Mr. Trustee,
I think that's right.
Mr. Hamilton,
Correct.
Ms. Winebanks.
I'm not sure I understand the premise of your question, so I
You
can't answer.
you cannot answer if there is a financial benefit to making campaign promises?
Making campaign promises is to win election.
You know,
I don't see that as a financial benefit.
I'm going to stick with you, Ms. Winebanks, as the Democrat witness here today. Can you answer how much money did District Attorney Alvin Bragg raise for his political reelection campaign immediately following the announcement of 34 felony counts against President Trump?
I do not know.
It's $850,000. $850,000. That's a good chunk of cash. Let's go on to the AG James. How much did she raise for her political campaign after her civil fraud case against President Trump?
I don't know, but it has nothing to do with whether the charges that she filed were based on the facts and the evidence and her
You and I
ability
both
to
know
prove
that's
them.
nonsense. Come on now.
I do not know that's nonsense. I believe it to
Not
be
a soul
true.
in this room actually believes that. And no one will ever believe that. It was $400,000. $400,000. And we will submit for the record copies of campaign emails soliciting donations. It almost seems, and I'm just stating the obvious here, that the harder they go after President Trump, the more money they stand to make. The common thread between all of these individuals, as well as the other cases that President Trump faces, is that many of the prosecutors suing Trump either have a personal vendetta or they seek to gain fame and money from it. This isn't hard. Those of us here today, we understand politics and what it takes to run a successful political operation. Traditionally, you want to drain your opponent's resources, drive up their negatives in the polls, and you want to keep them from engaging with voters. Now, I'm going to ask the million-dollar question here. What better way to do that than to charge your opponent with 91 counts, force them to spend millions on a legal defense, and tie them up in court to keep them off of the campaign trail? It's almost like this is a plan. This is a strategy that is employed in campaigns all around the country, but we are seeing it at the highest levels today. Of course, as an incumbent, you have an added advantage of using taxpayer-funded offices and agencies and officials, and we all know that you can never go up against the federal government because it is an endless stream of resources. Isn't that correct, Mr. Costello?
Without a doubt.
Exactly. If that is not what lawfare is, I don't know what is. Lawfare, by definition, is exactly that, utilizing the law to take down your political opponents. It is an abuse of power. Mr. Trustee, you said earlier a pretty chilling statement that you fear we have, quote, crossed the Rubicon, that the ends now justify the means. I feel like many Americans agree with you. Heck, if it weren't for double standards, I feel like our Democrat colleagues in this administration wouldn't have standards at all. But I feel that the credibility of our institution is at stake here because, to your point, the ends somehow have justified the means. I've pulled some research out of a Harvard Law study that suggests that district attorneys pursue crimes and longer sentences at higher rates during election years. So while DA Bragg and AG James' terms end in 26 and 27 respectively, and of course DA Willis is facing re-election this fall, is it crazy to question whether any of these prosecutors are weighing their re-election efforts in their choice as they pursue President Trump? Final word to you, Mr. Trusty.
Right. It's certainly not crazy, and I think that there's evidence that supports that conclusion. And again, I never get to the money part. If you're a prosecutor, you're not supposed to be a politician. You're not supposed to announce your target first and then search for an inventive way to charge them with heretofore unknown crimes in a lot of cases. So that's the problem for me, is not chasing down all the politics of how they stand to gain, but that as a prosecutor, you have a sacred obligation to pursue evidence, not people.
Absolutely, a predetermined outcome.
Correct.
Thank you to our witnesses for appearing. My time has expired. I yield.
The gentlelady from Wyoming is recognized.
Well, thank you. And if it seems like there might be a dog in this hunt on the other side, what you need to understand is that Mr. Goldman, the novice representative from New York, actually does have a personal stake in this case. He has stated that he has been involved with the Bragg case, helping to prepare Mr. Cohen for his testimony. So he is quite closely aligned with an admitted and convicted liar and perjurer. He's also paid the Judge Merchant's daughter's firm over $150,000 for her services. So I think we've got quite a conflict of interest from Mr. Dan Goldman, the novice representative from New York. And just one other thing to keep in mind when considering the hostility from the folks on the other side of this aisle is that the ranking member of this
Mr. Chair, I would move
committee
to have that
was Jeffrey
stricken from the record,
Epstein's
to have
fixer.
that phrase taken down.
The ranking member was Jeffrey Epstein's fixer. So I think that might give you
Excuse
some
me,
idea of
I
why
would
you
ask
see this
that-
hostility.
Hang on, the
Statements be
gentlelady,
taken down.
gentlelady, the
to
ranking
Mr.
member is
Goldman.
recognized.
I would ask that the statements regarding the conflict of interest related to Mr. Goldman be stricken down from the record. Engaging in personal personalities.
In your
on this
14-minute and 14-second opening statement, you called the former president, current candidate for the office of president of the United States, all kinds of names. I think
He's not a member of this
I
committee.
understand he's not a member, but
And
he's
that's what I'm
still
asking
a former
you related
president.
to.
What I'm saying is we should
I'm
all be
related
careful
to
about it.
our
I think the
member.
gentlelady from Wyoming was just stating facts that are in a news report.
She accused him of a conflict of interest on the committee during the hearing. I ask that that be stricken down.
Gentlelady's point of order is overruled. The gentlelady from Wyoming is recognized.
Thank you. Mr. Hamilton, would you agree that gag orders on trial participants were created with the intent of securing a defendant's right to a fair trial and ensure efficient administration of justice?
It's precisely correct. And it's in fact usually intended to prevent the prosecution from making extrajudicial statements that are going to be prejudicial to the defendant's rights.
And Mr. Trusty, I think that you testified that in all of your years of experience, you've never seen a circumstance where a defendant had a gag order imposed against them. Is that correct?
That's correct.
And would it be fair to say that while such an order is intended to guarantee a defendant's Sixth Amendment right, it also at certain times could raise First Amendment issues?
It does.
Okay. In Bragg's political persecution of Donald Trump, Judge Merchant instituted an unconstitutional gag order against the defendant, President Trump. Yet Judge Merchant has levied no such order against any of the other trial participants, like Michael Cohen, who continue to publicly attack Mr. Trump. Mr. Hamilton, is the gag order issued by Judge Merchant a significant departure from the normal order of business? And does it reveal the First and Sixth Amendment tensions which underlie this case?
Most certainly does.
And why does President Trump face such a legally questionable gag order in this case? Well, simply put, it's because it is a classic example of lawfare being employed by Democrats against their political opponent, weaponizing the various branches and levels of government, something that, as we have seen in the last 8 years, that has been absolutely shocking to the conscience. DA Bragg resurrected a zombie case and is using a novel legal theory which has not even been explained to the defendant or the jury. He selected Matthew Colangelo as lead prosecutor, a former Biden DOJ official and DNC consultant, and Judge Merchant, who made campaign donations to President Biden and the Democrat Party during the 2020 election, and whose daughter's firm worked for the Biden and now Harris campaigns, is overseeing the case and imposing speech restrictions on a person Judge Merchant called, quote, possibly the next president of the United States. Judge Merchant went so far in the last 2 weeks as threatening to jail a former president and presumptive major party nominee for violating an order which infringes on his free speech rights. Writing in The Federalist, Tom Christ analyzes how lawfare offers benefits and a means of victory regardless of the outcome of the courtroom, which is causing as much pain as possible and treating the defendant like an enemy versus the defendant. I want that to sink in. Watching Judge Merchant, it is very apparent that he is treating President Trump as an enemy, not a party and not a defendant. Mr. Hamilton, do you think the gag order falls into this playbook and serves an additional lawfare benefit for the left in that it can be used to enact an even larger legal burden on Donald Trump for simply exercising his right to free speech?
Yes, I do. And in fact, quite frankly, when you have a gag order like that, or when you have abuses of processes like this, as my colleagues have alluded to before, the pain in the process is the goal. That's really the goal here. Whether they get a conviction, whether they get any kind of civil fine or judgment, it's not necessarily the ultimate objective. The ultimate objective is to cause pain to the political opponent, and that's what they're doing to Donald Trump.
One of the things that I have observed as an attorney who was a trial attorney for 34 years, is that Judge Merchant is making such blatant reversible errors. He absolutely knows that if there is a conviction in this case, it will be reversed on appeal. And it's as though he is attempting to do that because he knows that no such appeal would actually take place prior to November, yet he would have a conviction on the books, which is the classic, and I think in this case exposes the way in which they are using lawfare against President Biden, or against President Trump. I have never seen a judge make the kind of errors that this judge has made in this case before. And I think he recognizes that if there is a conviction, it would be overturned on appeal. That is what our justice system has turned into because of the lawfare being waged by the Democrats. It has to end. Thank you for being here, and with that, I yield back.
The gentleman from North Dakota is recognized.
Thank you, Mr. Chair, and I'd yield to you.
Thank you. I thank the gentleman for yielding. Mr. Trustee, 17 years at the Department of Justice. Did the raid on Mar-a-Lago follow normal process?
I don't believe so.
You know who agrees with you? The Assistant FBI Director of the Washington Field Office, because we deposed it. And I just want to walk you through and say if what you saw squares with what Mr. D'Antuono testified to in a deposition in front of the committee. The Miami Field Office did not conduct the search. It's folks from Washington who came down and did the search. Is that unusual?
I would think so. You normally have at least some local component.
The department did not assign a U.S. attorney to head up the investigation. They ran it out of the field office. They ran it out of Washington, D.C. Is that unusual?
Well, I'm not sure it's unusual for DOJ attorneys to kind of assume authority in a vacuum. So, my understanding is Jay Bratt was involved from day one, and that continued through the search warrant, obviously.
Right, but normally wouldn't a U.S. attorney be assigned to it in most cases?
Yeah, and eventually they would show up for court, but I don't think at that part of the process they were an active partner.
Did the FBI seek consent before they conducted the research? Or the search?
No, actually, the last thing that President Trump said when he allowed FBI agents in Mar-a-Lago in June was, anything you need, let me know. The only communication that came from DOJ after that was a request to put a padlock on the door where they knew the boxes were. And then the next thing we know,
which the president complied with.
Which he did immediately, and 2 months later, there's a search warrant.
And then did the FBI wait when they got on premise, had it secured, did they wait for President Trump's legal team to be there and accompany them on the search?
There were requests by representatives of President Trump to be, in the vicinity of the search. Those were denied. That is a right of law enforcement. They don't have to. But for a case of this historical precedence, consistent with my earlier remarks, some transparency, some openness would have been probably a valuable moment lost here.
No kidding. Talk to me about, in your testimony, two other things. You mentioned the 14th Amendment. I mean, this to me struck me as just absolutely craziness, that they're going to go to state courts and try to keep the president off the ballot. Tell me your thoughts on this crazy concept.
Well, the Supreme Court unanimously agreed to end the nonsense of the disqualification litigation, but they never really reached the due process, which would have been a hornet's nest of going state by state and saying, how did they conduct these expedited trials? The fact that always grabbed me, and maybe this goes back to having a bad sense of humor, was in Colorado, they literally put a sociologist on the witness stand to say, when President Trump said, go peaceful and patriotically, I know from my Ouija board or whatever else he consults, that he really means be violent and attack the cops. I mean, that was considered admissible information in a hearing designed to take a presidential candidate off of a ballot. So I kind of wanted the Supreme Court to get the due process and join me in laughing at that, but they never got there.
Yeah, what he said, I've concluded, means exactly the opposite, and the court accepted that as evidence. Thank goodness the Supreme Court said 9-0, this is crazy. I want to read you one other thing from your testimony, which I just found amazing, and you briefly touched on it earlier. You said, if the this is a grand jury situation, in the grand jury, the prosecution said to Mr. Parlatore, if the president is being so cooperative, why won't he waive his attorney-client privilege? The fact that they asked that question in a grand, is, again, maybe as crazy as the whole 14th Amendment argument.
Yeah, I mean, again, nothing I'd seen in 35 years, and it was an over-aggressive moment of asking the grand jury to draw a negative inference from a lawful invocation of attorney-client privilege. That's just black-letter unethical for a prosecutor to do.
Yeah, scary, scary stuff that we see going on, all to go after their political opponent, and we could go on with example after example. I mean, the one before, where dangling the judgeship in front of a lawyer representing, when you got Jay Bratt and the DOJ there, is just, I mean, again, we could go on and on. I want to thank you both for testifying, and would yield back.